Mary Smith. And Ms. Smith, I'll ask you to call the first item.
The first item is an application by Markham Land Properties LLC for new TPDES permit number WQ00156970001 to authorize the discharge of treated domestic wastewater. The parties have been notified that the commissioners will not take oral argument but may ask questions, and we have no one signed in on this matter.
So Commissioner Lindley, on this one we have two requesters, Ms. Stroud and Dr. Honeycutt. Both own property near the discharge point. Both have raised relevant material issues. So I propose that we refer this for a contested case hearing, and I've identified the following issues: whether the draft permit is protective of the health of the requesters, as well as livestock, wildlife, and aquatic life; whether the draft permit is protective of the requesters' use and enjoyment of their property; whether it's protective of surface water quality and uses of the receiving waters; whether it's protective of groundwater; whether it's adequate to prevent eutrophication; and whether it's protective of the unnamed receiving tributary during low flow conditions.
I would agree on both Ms. Stroud and Dr. Honeycutt and those issues. And it doesn't sound like ADR is probably appropriate for this one.
I understand that they have been in ADR, and I don't know the status of that. I don't think that we need to instruct the parties to engage in ADR, because either it's ongoing or it's failed.
I agree.
So we'll leave that out of the motion.
Yeah, so I would not include that. But with that, I can make a motion if you're ready.
I'm ready.
Okay. I move that we grant the hearing request of Emily Stroud and Dr. John Honeycutt, that we refer the application to SO for a contested case hearing on the following issues. A, whether the draft permit contains sufficient provisions to protect the health of the requesters, their use and enjoyment of their property, wildlife, aquatic life, and livestock in the area. B, whether the proposed discharge under the draft permit will be protective of water quality and the uses in the receiving waters under the applicable surface water quality standards in 30 TAC Chapter 307. C, whether the draft permit is adequately protective of groundwater quality standards. D, whether the draft permit contains adequate effluent limits to prevent algae growth and eutrophication water bodies downstream from the facility. And E, whether the proposed discharge under the draft permit will negatively impact the unnamed tributary during seasonal flow. And that we set the hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 2 is the petition for the creation of the Conroe Municipal Management District number 2 of part of Montgomery County. The petitioners seek the district's creation and should present the matter, followed by any interesting persons, presently none signed in, the ED, and then OPIC. The Office of General Counsel recommends that each party have 5 minutes to make their presentation, and the petitioners may save time for rebuttal as they bear the burden of proof. Ms. Mallory Craig is here for the petitioners to present the item.
And Ms. Craig, if you want to step forward. Good morning. Can you check to make sure the light is on your microphone?
Lights are on.
Okay, we're good.
Can you hear me?
I can. Just identify yourself and your affiliation for the record.
I'm Mallory Craig with Coates Rose PC. I'm representing the petitioner CTM Holdings in the matter of the creation of Conroe Municipal Management District number 2.
And go ahead and just proceed. Thank you. Yeah.
We submitted the petition and application in accordance with Chapter 375 Local Government Code and 293.11. Our application shows all of the applicable points, boundaries, names of the district, the project costs, our purposes, the names of the directors to be appointed, that there are no similar services in the area, and that the City of Conroe supports our creation. At this time, the boundaries of the district are within the City of Conroe. When we submitted the application, it was in the process of being annexed into the city. It is now in the city. So we would just request that the Commission approve the creation of the district, and I'm available for any questions.
Thank you. I have none. Commissioner Lindley?
No questions, thank you.
Thank you.
Thank you.
And we have no interested person signed in, so staff.
Morning, Chairman Neerman, Commissioner Lindley, General Counsel, and OPIC. My name is Shay Pearson. I'm here with the Environmental Law Division, and with me is Andrew Painter from the district's team. The Executive Director received a petition from CTM Holdings LLC for the creation of Conroe Municipal Management District Number 2 of Montgomery County pursuant to Chapter 375 of Texas Local Government Code. We have reviewed the petition and concluded that all applicable requirements have been met, and the Executive Director recommends granting the petition for district creation. We're available for any questions.
Thank you. Any questions for staff?
No questions, thank you.
Mr. McWhorter?
OPIC recommends granting the petition for creation of Conroe Municipal Management District Number 2 as presented by the Executive Director.
Thank you. And Commissioner Lindley, I agree with that. I think the petition, it appears to meet all of the requirements of the local government code. The requested initial directors appear to be qualified. The district appears to be feasible, necessary, and a benefit to the public. So seeing no objections and on the recommendations we've just heard, I think we should go ahead and grant the petition and issue the order creating the district and appointing the initial directors.
I agree with all that. I move that we grant the petition for the creation of the Conroe Municipal Management District Number 2 of Montgomery County and issue the Executive Director's recommended commission order for creating the district and appointing 5 initial directors.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Items 3 and 4 are the consideration for adoption of 2 total maximum daily loads for indicator bacteria in Lavaca River above tidal and Rocky Creek of the Lavaca River Basin and the corresponding implementation plan. And the Executive Director's staff are here to present the item.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, I'm Kerry Neiman with Water Quality Planning Division in the Office of Water. With me today is Jasmine Milford of the Total Maximum Daily Load Program and Stephanie Scogan of the Environmental Law Division. Today, the Executive Director is respectfully requesting consideration for final adoption of 2 total maximum daily loads and approval of an implementation plan for indicator bacteria in the Lavaca River above tidal and Rocky Creek. The TMDL covers 2 assessment units in 2 stream segments within Calhoun, DeWitt, Fayette, Gonzales, Jackson, Lavaca, and Victoria counties. Excuse me. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDLs and making decisions regarding the implementation of the TMDLs. The success of these projects is due to the collaborative effort of the individuals and organizations that put in the time to develop these documents to improve water quality in their communities. The Executive Director respectfully requests the adoption of the total maximum data loads and approval of the accompanying implementation plan. Permission is also requested to make non-substantive and clerical corrections. Thank you, and we're available to answer any questions that you may have at this time.
Thank you. I have none. Commissioner Lindley?
No questions, thank you.
Mr. McWhorter?
OPIC recommends adoption of the 2 total maximum daily loads for indicator bacteria in Lavaca River above tidal and Rocky Creek and the corresponding implementation plan as presented by the Executive Director.
Thank you. Yeah, Commissioner Lindley, I think the TMDLs and I-Plan satisfy the requirements of the Clean Water Act and put us on a path to achieving the water quality standards, and I think it's appropriate to move forward with them.
I agree and appreciate all the work that our staff and all the stakeholders did getting this put together. With that, I move that we adopt the 2 total maximum daily loads and the corresponding implementation plan for indicator bacteria in Lavaca River above tidal and Rocky Creek of the Lavaca River Basin in Calhoun, DeWitt, Fayette, Gonzales, Jackson, Lavaca, and Victoria counties as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 5 is the annual review of financial assurance mechanisms and cost estimates for radioactive material license number R04100 held by Waste Control Specialists, LLC. The ED will present this item, and currently no one is signed in to speak on the item, and the ED staff are here to present.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel.
Can you make sure that the light's on your microphone, or maybe pull it closer? I'm not hearing you real well.
It's on.
Okay,
Thank
great.
you. Good morning, Chairman, Commissioner, General Counsel, and Public Entrance Counsel. On behalf of the Executive Director, I'm Brad Broussard with the Radioactive Materials Division. With me is Ashley Forbes, who's the Director of the Radioactive Materials Division, and Aaron Vargas with the Environmental Law Division. In compliance with 30 Texas Administrative Code, Section 336.736C, Waste Control Specialist Financial Assurance Mechanisms and Cost Estimates are reviewed to assure that sufficient funds are available for completion of low-level radioactive waste disposal site closure plan. Included in your backup materials is the Radioactive Materials License Financial Assurance for Waste Control Specialists for your review and approval. Thank you for your consideration, and we're available to answer any questions.
And I just want to confirm my understanding of this. This package is really exclusively about adjustments to account for inflation, and there really aren't any substantive changes in the closure plan associated with this package.
Yes, sir, that's correct.
Thank you. Any questions?
No, I appreciate that question or comment, and appreciate the scrutiny and the review that goes into, or that went into this package that's before us today.
Mr. McWhorter?
I appreciate the review, and I don't have any objections or concerns about the information presented for this item.
Thank you. Commissioner Lindley, I think we're
I think we're
good to
ready.
go.
I move that we approve Waste Control Specialists' financial assurance mechanisms and cost estimates as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
Thank you.
Item number 6 is the consideration and approval of the agency's fiscal year 2020 operating budget. We have no interested parties signed in, and the executive director's staff is here to present this item.
Good morning.
Good morning. Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, I'm Elizabeth Cifuentes-Cook, the Director of Budget and Planning Division. With me is the Budget Manager, Connie Farrington. I'm going to present the Executive Director's recommended fiscal year 2020 operating budget. This information was compiled in accordance to the General Appropriations Act passed in the 86th legislative session. If you'll turn with me to page 1 of the recommended operating budget document. That first page represents a comparison of our 2020 budget compared to our 19 budget. It's a difference of approximately $25 million. In 2020, our budget is $400 million. In 19, that budget is $374 million. The majority of the differences are associated with riders. We receive funding for litigation for the Rio Grande Compact Commission, also air quality planning grants, and a pass-through funds to University of Houston for supercritical carbon dioxide technology. And then we also have funding for Donna Canal remediation for state contribution. And then we received increases in our capital budget by approximately $4 million. Our FTEs also increased to 2829.3, which is a difference of 34.5 FTEs. Okay. The following page is a illustration of our method of finance. You'll see the majority of the funds are fee at 82%.
Do you know off the top how that compares to the fiscal year 2019?
In 2019, we had 83% in fee funds. So our percentage is going down, although our allocation is greater. We have increases in general revenue that's causing a change in percentage.
I understand. Thank you.
The following page is a comparison by office of FTEs. Overall, you'll see that change of 34.5. Executive office has a reduction of 32.75, which is the result of the reorganization of the Environmental Assistance Division that moved over to the Office of Compliance and Enforcement. Office of Compliance and Enforcement also received an increase of 8 FTEs for the municipal solid waste investigators. Office of Administrative Services is going up by 7.5 for an exceptional item of implementation of the CAP system. And then Office of Air received 10 for expedited. And then we have 9 FTEs within agency-wide, which is our placeholder for delegation of produced water once we receive that from EPA. The following.
I like that comment, once we receive it. Appreciate the confidence.
We'll receive it.
We will.
Yeah.
The following page provides a comparison of the budget by office. Overall, you'll see that change is $25.5 million. The majority of that change is within the Office of Water and Office of Air. Office of Water received an increase for the litigation of $5 million. We also have a funding for water availability modeling at 2.2, and then we have some change in federal funds, the remaining. Office of Air received the air quality planning grants of $4.5 million. Also that supercritical carbon dioxide pass-through funds. And then we have some riders that are front-loaded in 20, so causing a variance compared to 19. The following page provides a comparison by budget category. Our overall changes are mostly identified within the professional and temporary service category at $11 million, and that has to do with that litigation funding, the water availability modeling, some federal fund changes and capital changes. The other significant increase is within the other remediation and reimbursement and grant contracts. That's for the $4 million for the supercritical carbon dioxide, the $4.5 million for air quality planning, and then the $2 million for the remediation of the Donna Canal Superfund site. The following page provides provides detail of those remediation, reimbursement, and grant contracts for FY20.
I think I'm good.
Okay.
Commissioner Lindley?
I'm
Wanna
good.
make
Yeah,
sure
we're
we
with
are-
you.
No,
Thank you.
appreciate it.
Just don't want to move too fast.
No, you're fine.
Thank you.
The following 2 pages are information regarding our capital budget. You'll see overall our capital budget is increasing by $3.9 million, mostly due to the monitoring equipment we received for the mobile monitoring and then also the scanning electron microscope. And then we also received an increase in our data center by $1.4 million. And that concludes my presentation. I'm available if you have any questions. Otherwise, we would request approval of the 2020 operating budget.
Thank you. I do not have any additional questions. Commissioner Lindley?
No additional questions. I think I would just want to take a minute to recognize and thank all the work that went into preparing the budget, all the work that went into session. I love talking about the budget, so this was an interesting session to get to really dive in on it and learn it from this perspective. And just a thank you to the Ledge, who's probably not listening, but for the funds, for the FTEs we got. I think we had a really good session, and that goes to a lot of the work done by a lot of the employees in this room. So it's exciting to have more money for WAMs and for mobile monitoring and expedited permits and for OCE. So I am ready to move forward with approving this budget when we're to that point.
Yeah, and just let me echo those sentiments. I really appreciate staff's handling of this, from front to back, and I'm glad to be where we are right now. So thank you.
Well, I appreciate it, and call me anytime you want to talk budget.
Mm-hmm. Oh, I will.
Mr. McWhirter?
OPIC recommends approval of this item as presented by the Executive Director.
Thank you.
Thanks.
This budget clearly is appropriate to meet our needs for the upcoming fiscal year, and I'm prepared to approve it.
I agree. I move that we approve the Commission's fiscal year 2020 operating budget as proposed by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
That takes us to the enforcement docket, items 7 through 10 and 12 through 26. Item 11 was remanded on the motion of the executive director, and the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens and Janice Hernandez of the Litigation Division representing the Executive Director. Pending before you are items 7 through 10 and 12 through 26. The total assessed administrative penalties are $232,115, with $34,010 deferred, $53,589 applied towards supplemental environmental projects, and $144,516 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. I have none at this moment, but we have an individual who's signed in to speak on item 8, and I'm going to call that person up in just a moment, so I just want you to be take a look at that. Commissioner Lindley, any questions
No
at this time?
questions, no, thank you.
All right, is Mr. Cantu present? Morning, sir. Thank you for being here.
Good morning. Thank you for having me.
So your mic is definitely on. That's good.
Is that working?
Yeah,
Can you
we
hear
can
me?
hear you. We can hear you well.
Thank you.
Please just identify yourself
Yes.
and your affiliation for the record.
Sure. I'm
Yeah.
Rodrigo Cantu. I'm an attorney with Lone Star Legal Aid in Houston. I'm here representing Port Arthur Community Action Network. You might know them as PECAN. They are a Texas-based nonprofit out of Port Arthur that focuses their work on low-income and minority residents and communities. And before I start, do I have a time limit on this?
It's
Or-
We generally recommend 3 minutes.
3 minutes.
Okay. All right. Thank you. So before I begin, I'd like to thank Chairman Neerman and Commissioner Lindley and General Counsel Smith, as well as the Office of the Executive Director and OPIC for providing me with this opportunity to speak on item number 8. First, I'd also like to say that Pecan is pleased to see that penalties will be assessed to the Oxbow facility in Jefferson County regarding a series of air quality violations from 2017. But we'd like to take advantage of this opportunity to impart on the commissioners that there are 2 critical errors that have been that we've spotted, and that these errors need to be corrected in order to bring the penalty into compliance with the agency's penalty policy. So first, the violation in question might actually be understood as a series of several violations, but what is most concerning to Pecan and to residents of Port Arthur are the 2 following issues. One is that the violation has been calculated as an actual moderate violation, but should instead be classified as an actual major violation, which would bring the penalty into compliance with the penalty policy. The second issue is that respondent Oxbow was granted a good faith effort penalty reduction despite failing to complete all of the corrective actions associated with this violation, which is required by the penalty policy. So as to the first issue, when you look at the penalty policy, the only difference between an actual major violation and an actual moderate violation is whether or not levels that are protective of human health and the environment have been exceeded, and that's determinative. In this case, Oxbow exceeded the primary 1-hour annual ambient air quality standards for SO2, which is the baseline level that has been determined to be protective of human health and the environment. To classify this violation as an actual moderate violation and not an actual major violation is not in accordance with the agency's penalty policy, and this is the first of 2 errors that we think needs to be corrected. As to the second issue or error, the penalty calculation worksheet notes that a good faith effort to comply was awarded, specifically because Oxbow has ceased to use 2 of its cold stacks. However, Oxbow has failed to obtain a permit alteration application for NSR permit number 45622 that would actually remove the authorization to operate these same cold stacks. In other words, Oxbow has only partially complied with the corrective action, and it is therefore not entitled to the good faith effort penalty reduction, which is in accordance with, which is what is normally required and has been required in the past under this penalty policy. So in conclusion, we'd just like to emphasize that the Pecan is pleased to see that a penalty is going to be assessed, but that Pecan and the residents of Port Arthur would like to see these two errors remedied following a remand to the executive director, and that a new penalty calculation be assessed at that time.
Thank you, Mr. Cantu.
Thank you very much.
Let's give the ED a chance to respond to what you've heard, and then we'll hear from OPIC.
Thank you, Chairman. The classification of the emissions as actual moderate, we did discuss the very issues that were brought up in the comments. It was our conclusion that exceedances of this particular air quality standard for an hour in some instances and 2 hours in some instances didn't in and of itself warrant an actual major designation. And so we classified it as actual moderate. There was a significant amount, but it didn't exceed protective levels. Now, you know, it's a judgment call. So that was the thinking on that one. And on the good faith effort to comply, the violation was stemming from the operation of the cold stack, and the respondent voluntarily stopped using the cold stack and stopped using it on that date, and said that they were not going to use it anymore, and we're going to get a permit amendment to I guess not allow them to use the cold stack anymore, that it wouldn't be permitted, because currently they were permitted and able to do that. It was causing the exceedance at the monitor, and so they stopped using it, and we saw that as a good faith effort to comply, even though they hadn't gotten the permit alteration yet.
All right, I don't think I have any questions for you at this moment. Commissioner Lindley?
No, not right now. Thank you.
Mr. McWhorter?
Based on OPIC's review of all the items, including this one, we found that it did comply with the penalty policy, and we concur with the comments of the executive director's staff on this and support the proposed order.
Thank you. Commissioner Lindley, thoughts?
I appreciate Mr. Cantu traveling here today and making his comments. You know, my review is that I would be comfortable with moving forward with adopting the items as proposed by the executive director. So that's where I kind of am.
I hesitate because I haven't studied this in depth, and so I'm not sure where I would land after studying it. And what I might recommend is, I think it would be premature to remand it, but I might recommend that we continue the item just so I can do my homework on this in light of the comment that we received today.
To the next agenda, or is that how that would work?
Yeah.
Yeah, we can, if that motion is approved, we can continue the item to the next agenda, to the August 28th agenda.
Are you all right with that?
That's fine.
Appreciate it.
You want to do a motion? Well, are there others we need to hear from?
No, there's just the one person signed in, and is there anyone here representing Oxbow Calcinating? Good morning.
Chairman Neerman, Commissioner Lindley, General Counsel Smith.
Mr. McDonald, will you check your mic and make sure?
That's green, so can you hear me here? Hello, hello?
Try it again. Yeah, I
Yes.
think we're good.
All right, so I'm Derek McDonald with law firm of Becker Botts for Oxbow Calcining, the respondent here. First, I think it's important to note, I think y'all were generous in allowing Mr. Cantu to present comments to you today, but this agreed order was the subject of a 30-day public comment period that was published in the Texas Register. He's provided no explanation for why he didn't take advantage of that period of time to present any comments or questions he had about the proposed order, so other staff and everyone else could have responded to those. So I think that's a concern on my part from a procedural perspective. As it relates to the substance, I think this is an important order to go ahead and move forward with. Oxbow and TCEQ, shares the state interest here in ensuring that this area is the sulfur dioxide national air quality standard for Port Arthur is maintained. And when it recognized and saw certain concentrations at the Port Arthur monitor in 2017, it took action to address those exceedances, reported them to the commission, and worked with enforcement staff to address those circumstances. We think the actions that we took in 2018 have effectively addressed the matter, but we're obviously waiting for this particular order to be issued before we take any final action with regard to altering our permits to address the use of the cold stacks. So we have actually been waiting for this day to get this order issued to be able to obtain and do the very relief that Mr. Cantu is asking for today. With regard to his comment about actual major...
And if I could interrupt
Yeah.
right there, I've got a question about that. Are we talking about making on-the-ground operational engineering changes, or are you talking about submitting the application?
It's the permit that Oxbow has affords it two manners of operation of that facility. The particular exceedances that are the subject of this order related to one mode of operation, and what the alteration would do would be eliminate that mode of operation.
Okay, so they've already made that change on the ground at the plant. This is just getting the authorization to catch up with that change.
That's correct.
Okay.
That action was put in place in June of 2018, and since that action has been taken, Chairman, no further exceedances have been noted at the Port Arthur monitor. So we're confident that that is the right fix for the concentrations that were being observed at that monitor.
Thank you.
So we think it's important to move forward today. With regard to the way the actual major versus actual minor, that was something that Brian and Michael and the other enforcement staff looked at very closely when this was being discussed, and I believe they even conferred with the toxicology department about that to make sure that they were comfortable in calling it an actual moderate. And I think the reason for that was that it's really it's a 1 hour standard, but it's on an annual average. And when you look at those concentrations over an annual average, they are not so high as to raise to the level of a major.
Thank you. And how would you articulate, if we were to continue this to the next agenda and for the sake of argument, approve the agreed order as is at the next agenda, how would that approximately 2-week delay prejudice your client? Sounds like it would delay them in filing the application, which would authorize them to do what they're already doing. I say authorize, it's actually
The reverse.
further
Sure.
limiting their ability to operate.
Except for the procedural issues that I do have concerned about, that someone shows up here at the last minute, the 11th hour, untimely, and raises comments that then create burden both on the staff as well as us to come up here twice to present to you. As much as I like to be here, it is an additional burden on our end. So we would request that you move forward today with the approval of this particular order.
Any questions, Commissioner Lindley?
No, I'm glad the comment was made about the 30-day public comment period, because I hadn't gone there in my head yet, that the public does have an opportunity to provide comments. And, I guess the understanding is none were provided. And so that actually kind of makes it more difficult for me to want to delay taking any action on it, just because I don't want to get in that practice. So it's not a question for you, just more of a comment. But we can.
I think that's a very good point. I
Yeah.
appreciate that. Thank you, Mr. McDonald. I'm going to give Mr. Cantu an opportunity to respond to the procedural question, specifically why did Lone Star Legal Aid not avail itself during that 30-day comment period, if that's the case?
Well, this is an opportunity for us to to speak on the matters that are right before the commission. So this is our sort of our last chance to be able to highlight these errors, and really they are errors, and this is the last opportunity that we have to correct those errors. And it's within the commission's discretion as to whether or not they want to send it back. A 2-week delay is not that much, given that if they haven't been operating the cold stacks since I believe it's June of last year, just over a year, what's 2 more weeks to really give it that detailed review that I know that we all really like to see when it comes to these issues. So that is my response to that question.
Okay, so your position is that you're admitting that your organization did not avail itself of the opportunity to provide comments during the 30-day comment period, but that you still have procedurally the right to come before us and provide those comments here.
That's correct. These are items. This is an open meeting where the public is allowed to comment, to highlight at the last minute if there's some issue that we think might have been just simply missed by staff and is going to be approved. And this is that opportunity that the regulations allow for.
Okay, thank you. I appreciate that. And the legal question in my mind, I don't know the answer to that, so I'll pull staff and OPIC here in a moment to see what to get their advice. But I appreciate that. I think you've answered my question, Commissioner Lindley.
Thank you.
No question.
Thank you for allowing me the second opportunity to speak.
Yeah, thank you. Staff, thoughts on what you've heard, and particularly around the procedural objection that Mr. McDonald raised?
I think that Mr. McDonald is correct in that the Lone Star Legal Aid did have a 30-day public comment period in which to make comments about this proposed order. I think also this is an open meeting, and Mr. Cantu can come forward and have an opportunity to address the commission. I share Commissioner Lindley's concerns that this might set a precedent. Obviously, we have public comment periods so that we can make thoughtful responses to comments that are made and give us time to reconsider if we need to reconsider. Mr. Cantu characterized this as an error, and I think we heard Mr. Sinclair say that they actually considered the very things that Mr. Cantu brought forward and made a conscious decision that actual moderate was the correct classification for this violation. So those are my comments on that. If I can answer any questions, I'd be happy to do that.
Thank you.
Sorry, I didn't identify myself. Charmaine Backens with the Litigation Division.
Thank you.
Thanks,
I don't have any additional questions for
No.
staff at this moment. Commissioner Lindley?
No other questions. Thank you.
Mr. McWhorter?
As for the procedural issue, I view it as really a matter within your discretion. I don't think legally it cuts one way or the other. Obviously, it would be preferable if they brought their comments forward during the 30-day comment period, but I don't think the fact they didn't do that bars them from bringing them today, and you exercising your discretion to continue the matter for further review if you so choose. Really, that's all I have to add.
Thank you.
Appreciate that.
Commissioner Lindley, I'm really torn on this. I don't want to create a precedent of allowing folks to skip the 30-day comment period and then provide comments at the agenda that further delays our actions on the one hand. On the other hand, I don't know where I would come out on the penalty if I were to study this independently. I often rely on the advice of staff and OPIC, and here they're aligned on their recommendation on the substance of it, the penalty. So that means a lot to me. I wish I had done a little bit more homework, which kind of goes to the point of not being on notice that we would have these comments at our hearing, but not have the benefit of them during the comment period. And maybe I have three hands. On the other hand, on the third hand, I don't see that Oxbow is prejudiced all that much in delaying 2 weeks because they've already made the operational changes. This is in a sense having the authorization catch up with their current practices on the ground. So I'm not sure how to weigh all those things, but I think I'm getting a sense of where you come out, and I want to ask your opinion.
You know, I appreciate the discussion today, and you know, my feeling is that I would have appreciated comments in the 30-day period, but again, it's not legally binding, I guess, might be the right terminology, that they have to comment then in order to comment today, because today is a public meeting, and I agree that it's a last chance to highlight efforts, but I don't like to get to the last chance. I would prefer that to be brought to light prior to. That way, if staff or OPIC or whoever it might be needs to dive into it more or provide more for us before we view it, that is what I prefer to have happen. And I think we agree on that. I am on the opinion that because OPIC and the ED came to the same conclusion, I'm comfortable with what's proposed today, and the enforcement penalty amounts and what was agreed to. So I am comfortable moving forward, adopting today the executive director's recommendation as opposed to delaying it 2 weeks. I think I'm not sure what other scrutiny I could provide, and so I think the amount of scrutiny that's been done is probably the appropriate level, and so that's why I'm comfortable moving forward today.
Those comments are really helpful for me, I think right on point. And in this case, if we were talking about another matter, you know, perhaps if staff or OPIC were coming out differently on their recommendations, or we were talking about something in an agreed order that was more than just turning the dials on major, moderate, minor, or turning the dials on good faith or not. You know, if it was something of greater substance than that, I think I would be compelled to continue this. But given everything I've heard, I think I'm ready to move forward with this. I do want to thank Mr. Cantu for being here, and Mr. McDonald. But I think I'm ready to move forward with this item.
Well, then I move that we adopt items 7 through 10 and 12 through 26 as recommended today by the executive director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Items 27 through 31 are the quadrennial rule reviews for chapters 90, 116, 279, 292, and 336 of Title 30 Texas Administrative Code, and the executive director's staff is here to present these matters.
Good morning.
Good morning. Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. On behalf of the executive director, my name is Patricia Duran from the General Law Division. And with me this morning is Booker Harrison from the Environmental Law Division. Pending before you are items 27 through 31, the adopted rule reviews of 30 TAC chapters 90, 116, 279, 292, and 336. As required by Texas Government Code Section 2001.039, executive director's staff conducted a rule reviews of these chapters to determine if the need for the rules within these chapters continued to exist. The proposed notices of the rule reviews were published in the March 1st, 2019 issue of the Texas Register. Public comment period for these reviews closed on April 1st, 2019. No comments were received during the public comment period for these reviews. Based on the review of these chapters, the executive director has determined that the reasons for the rules continue to exist. Additionally, during the course of these reviews, the executive director determined that the following are obsolete and no longer needed and will be addressed in a future rulemaking action. 30 Tax Section 116.16, Section 116.128, and the rules within 30 Tax Chapter 116, Subchapter H, due to the expiration dates and application deadlines in statutes and rules that have passed, and 30 Tax Chapter 292.1, Subsection A, due to the abolishment of the Texas Water Advisory Council and the repeal of Texas Water Code Chapter 9. We respectfully recommend approval of the adoption of the rule reviews of 30 Tax Chapters 90, 116, 279, 292, and 336. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and attorneys assigned to these chapters are here to answer any questions.
Thank you. I have none. Commissioner Lindley?
No questions, thanks.
Mr. McWhorter?
OPIC recommends adoption of these reviews and readoption of these chapters as presented by the Executive Director.
I agree. I think that's appropriate with instructions to the executive director to initiate separate rulemaking to deal with the identified obsolete provisions.
I would agree. With that, I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code, Chapters 90, 116, 279, 292, and 336 without amendment, and direct the executive director to initiate a rulemaking to eliminate the obsolete subchapters and sections identified by the executive director in 30 Texas Administrative Code, Chapters 116 and 292, prior to the next quadrennial rules reviews of the chapter. Got tongue-tied there.
The motion has been made. I second it. All those in favor say aye.
Aye.
Motion carries. Thank you.
Item number 32 is the public comment session, and we don't currently have anyone to speak, signed in to speak at this time. And
Seeing none.
that takes us to the end of the items for open session, and the commission will meet in closed session in room 4222 at Building F at 10:30, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider the matters pursuant to items number 33 through 36 as noticed.
The time is 10:17, and we stand in recess. How are we doing back there? Good. The time is 11:09. We are back in open session, having just met in executive session where Commissioner Lindley and I voted to approve a salary action increase for our general counsel. And what else do I need to do to perfect that action since we've voted on it in executive session?
That's it.
Okay. So I think our business is concluded, and the time is now 11:10, and we are adjourned. Thank you.